Thank you so much for joining us today. Career coaching and mentoring class is brought to you by Sedat Consult with support from Logo Brand. Please contact Logo Brand on 020-39524216, 020-395-4216 for all your branding and graphic designing needs. Today we are discussing the important topic of employee rights and obligations, or rights and duties. And we are privileged to be hosting one of Ghana's and Africa's best labor consultant, who is also a labor law expert or an employment law expert, Senyo Adjabeng. Senyo Adjabeng is an international consultant. He is a USA certified senior HR professional. He's an employment law expert, labor consultant, mediator, and arbitrator listed with the National Labor Commission, and he's also the workplace investigation expert. Mr. Adjabeng is also the author of the highly sought after book, Career Toolkit for Successful Job Hunting, and several articles on human resource management, dispute resolution, and corporate governance. Mr. Adjabeng is a trained non-executive director and member of the Institute of Directors, Ghana. His specialization is in employment relations, in mergers and acquisitions, workplace investigations, and employment law. Senyo has a total of 17 years work experience, 3 years in dispute resolution, 14 years direct human resource management experience, 9 years of which was in consulting, and 5 years in executive human resource management in the banking and construction sectors. Currently, Senyo is the country HR manager for WBHO, which is a multinational civil and mining construction firm. It's indeed a privilege to be hosting Senyo. Thank you so much, Senyo, for joining us. Like I said, Senyo is an international consultant. He is a labor consultant, he is an employment law expert, and he's also a workplace investigation expert. Thank you so much, Senyo, for joining us. We are privileged to be having you once again. Thank you. I know how busy you are, but I also know the fact that you always want to share knowledge and impact lives, and we are privileged to have you here once again. Thank you so much for joining us, Senyo. Please, you can unmute yourself.
Yes, thank you.
You're welcome, Grace. But Senyo, let's start from the basis as usual, looking at who an employee is, or like you said on Instagram, who a worker is. If you can help us understand that and the various categories or types of employment contracts that we have in Ghana.
Great. So I mentioned that normally our laws do not deal with the word employee. Employee is more like an internal terminology that you find in various policies, HR policies. But the law deals with the word worker. And a worker basically is a person who has a contractual relationship with an employer, or someone who has engaged them for their labor services. So that's who a worker is. So a worker always has a form of contract of employment with an employer, someone who is paying them for their labor services. However, the interesting thing is that an employment contract need not be in writing, especially if it is for less than 6 months. It needs not be in writing. So it means that we can have contracts of employment that are verbal in nature. And once they are verbal, then it does not mean they are not binding and enforceable, because there are certain features of a contract of employment that we can see even in a verbal contract of employment. And so people don't have to be too worried if they have contracts or they have, jobs that do not issue them specific written contracts, especially if those jobs are less than 6 months. They only have to start worrying if they have jobs that are for more than 6 months or more, and it is not secured by a written contract of employment. So basically that's what a worker is, and that is what contracts of employment are. But the types of contract we have would depend on some two types of contractual relationships that we have in employment relations. And the first one is the contract of service, which results in a contractual relationship that pays for time, for the employee's time. So it is continuous in nature, and it is the employee's time that is paid for. So a worker works for 8 hours a day, 40 hours a week, and at the end of the month, the employee is paid a salary, or the employee is paid wages in accordance with the number of hours the worker works, and is paid on the basis of a weekly number of hours worked, weekly or monthly, and then they are paid according to that. That is the contract of service. Contract for service is contract for labor services that results in or is based on an independent contractor relationship. So if you invite a carpenter to come and repair your door, you are not paying them for the number of hours they use to repair the door, but you are paying for their skills and their professional skills in resolving, the challenges with the door for you. That is what we call contract for service. So when we talk about types of contract, I wouldn't want us to go too much into the types of contract for service, but we can go into the contract of service, because that is what we normally have, commonly in our workplaces. So the first one is a continuous contract of employment or contract of service, which is for jobs that are maintained throughout the year and continues from year to year as a going concern. So the jobs in their nature are available and they are maintained throughout the year. And people in continuous employment work on a daily, monthly, and yearly basis until they reach the age of 60, when they mandatorily have to retire. So that is permanent employment, continuous employment. Then we have temporary employment. Temporary employment is also a type of employment which sometimes we call as contract work. We call it fixed term contracts. We call it employment at will. We call it all manner of names, but basically they stand for temporary employment. And temporary employment or temporary workers are those that are engaged in work that are for more than a month. Okay, they are not seasonal and they are not intermittent. So they are for more than a month, they are not seasonal and they are not intermittent. Often temporary contracts are used for work that are project-based. It means they have a definite beginning and an end period. And that's why we call them fixed term employment. That is the temporary employment. So the duration of temporary employment can stretch from 1 month to 59 years, if you ask me. So it's very broad. It can be used for 6 months duration, 1 year duration, 3 years, 5 years, 15 years, 20 years, depending on the type of job that the person is engaged in. Now, then we have casual employment. Casual employment is for jobs that are seasonal and intermittent in nature, and they are for not more than 6 months. So casual employment cannot be for more than 6 months. They range from between 1 day to 6 months. And they are for jobs that are not continuous. Jobs that are intermittent, and seasonal is what you can use contracts and casual employment contracts for. So you sometimes find employers making a mistake of giving the name casual workers to unskilled workers. Unskilled workers are not casual workers. We can have permanent workers who are unskilled. We can have temporary workers who are unskilled. The only time that we can justify casual work is when it is maintained for less than 6 months. It is for jobs that are seasonal and intermittent in nature, and jobs that are not maintained throughout the year. So if a job is a short-term job, that would be a casual employment. So if you have an unskilled person in a continuous work, but you keep calling the person casual, the law will not protect you if you then are taken on because you treated the person like a casual worker when actually the person is in continuous work. Then we have other types of work like piece work, work for seafarers, work for, then traineeships are also types of work. So like apprenticeships and traineeships are also types of contracts that we can have under our laws. Yeah.
Yeah, I realized that especially for management level positions, usually when you look at the contract letter, it gives a definite term. So for example, a 1 year or 2 years contract, and they will say is renewable based on, does that fall under the temporary worker or the fixed term employment contract that you spoke about?
Yes, it falls under the temporary work.
Oh, okay.
Okay, but the trick is that people then abuse continuous work, meaning that they break down continuous work into bits and pieces and support them with temporary contracts or fixed term contracts. And that's problematic because then when the job is scrutinized, we'll find that the job is a job that exists and is maintained throughout the year. It is not a fixed duration job. It's not a project-based job. And so it is not continuous. It is just broken down so that the employer would not incur more cost on that kind of labor as though, or if a permanent person was put in the role. And when the renewals continue, it can be referred to as exploitation of labor, because then you are using continuous work, you are abusing continuous work using a wrong type of contract to exploit the labor or to cheat or to breach the rights of the employee in that job, because the employee would be doing a job that is continuous in nature, but the contract that is supporting the job is not a permanent contract. So employers use that to cut costs, okay, cut labor costs, and at the end of the day, they breach the regulations of the law, the provisions of the law regarding the types of contract that must be issued for specific types of work. And that is where the problem is. I have argued, before the National Labour Commission on the basis of this kind of thing where you had people continuously renewing contracts, short-term contracts, renewable. And I argued exploitation of labor, and I got compensation for my clients. So it is something that we need to watch. We need to assign, or we need to use the right contract of employment for the right kind of job so that we do not fall into trouble.
Well, this is revealing, because sometimes even HR managers, you see that the letter given is for 1 year, and they will say 1 year, but the business is a going concern, and the person is working continuously, yet every year the letter is, or the contract is renewed. So that means that there's something wrong. And as HR professionals, you also keep on issuing such contracts, to people. So then it means that if you are not careful, then we'll have a problem. So then what it means is that before you even issue, to know that this is the type of work, employment, and this is the type of contract I need to issue, you also need to consult a labor consultant like Senyo, so that we'll be clear in our mind, so that you don't want a situation where you'll be taken to the Labor Commission and Senyo, you meet with Senyo will win the contract for the client. So before it gets there, make sure you see him so that it doesn't get to that point at all. Thank you, Sonia. This is very revealing. So we should be mindful how we craft our employment contracts. We should know the type of employment and the type of contract or employment letter to issue. So let's look at the labor law, because most of us know that the employment relationship in Ghana is actually governed by the labor law. Are there any other laws that govern employment relationship in Ghana? If you could share that with us.
Yes, sure. So the labor law is the primary law that regulates, employment, between the employment relationship between employers and employees, or employers and workers. But we have other laws. For example, the labor law has two regulations, which is the National Labour Commission Regulation of 2006, LI 1822. We have the Labour Regulations of 2007, LI 1833, and these are regulations that administer aspects of the labor law. Then for pensions, we have the National Pensions Act, National Pensions Act, Act 766 of 2008, I think, that regulates pensions, the three-tier pension scheme in Ghana. We have a law that regulates injuries and incapacity, in the workplace, called the Workmen's Compensation Act. Workmen's Compensation Act, PNDC Law 187 of 1987. That is the Workmen's Compensation Act. It is for compensating workers that get injured on the job or who die on the job. Occupational deaths and injuries are regulated through that law. Then we have Factories, Offices and Shops Act, which regulates how offices and factories and shops are supposed to be maintained, especially for employees to work in that kind of environment. There's a regulation on what the workplace should have, how it should be, the sizes, the heights, windows, cleaning facilities, sanitary facilities, water, and all of those things. That law regulates that. And so there are all of these basic laws that regulate relationships in the workplace. In the public sector, you have the Fair Wages and Salaries Act, which set up the Fair Wages and Salaries Commission to regulate issues of salaries for public sector workers. So that is also there, and so on and so forth. So we have various laws that regulate employment. The last one I think I can mention is the law that regulates dispute resolution, in the country, and the labor law is subject to that law. That's the Alternative Dispute Resolutions Act of 2010, Act 798. That law is the law that regulates disputes, alternative dispute resolution in the country. And that for labor, the main method of resolving disputes is ADR. And so that is what the labor law uses. And so the labor law is subject to, the ADR Act as well. So all of these ancillary laws then go to help and to support, the labor law and also the relationships between employers and employees in the workplace.
Thank you so much, Senyo. So then let's look at the bodies that are responsible for the regulation or ensuring that the laws are really, in line and people obey the law.
So the National Labour Commission is established by the Labour Act in Section 135, And their functions as per Section 138 of the Labour Act is supposed to have them, facilitate disputes and to facilitate the resolution of disputes between parties. So that is their primary role, and also to regulate the employment relationship. So if there's any issue with the employment contract and it results in a dispute, the primary organization, adjudication body to go to is the National Labour Commission. However, there's also the specialized high court, the Labour Court, which is set up by the judicial service, to also help employees and also employers who want to have disputes resolved regarding their employment relationship. So the courts are also there. The High Court has original jurisdiction over all other lower courts and quasi-adjudication bodies, including the National Labour Commission. So the Labour Commission is subject to the authority of the High Court. So someone who is not happy with the Labour Commission can also go to the High Court. And when they have issues, they can go to the High Court straight away, but also can do the National Labour Commission same way. Then we have institutions like SHRAJ. SHRAJ is specialized in discrimination issues, administrative justice, especially for the public sector, and also harassment, sexual harassment issues, gender discrimination and all that. So where parties have issues along those lines also, they can approach SHRAJ to help them resolve the dispute, and SHRAJ will have the jurisdiction to be able to handle those kinds of issues. So for me, these are the three main, bodies that help manage and, regulate, the employment relationship in Ghana.
Okay. Thank you so much. So now let's then move to the meat of the discussion. We are looking at the rights and obligations of the employee or worker as the law wants us to use. What are the specific rights as enshrined in the Labour Act that employees need to be aware of?
Well, the rights and obligations, the rights of a worker is found in Section 10 of the Labour Act. And so, for example, an employee or a worker has the right to work under satisfactory, safe, and healthy conditions. And that is a right of the worker. So if the worker is working in an environment that is not safe, it's not healthy, and it's not satisfactory, reasonably satisfactory and reasonably comfortable for human for humans staying in that kind of environment and working in that kind of environment, then that right is going to be breached. Okay, so you remember I mentioned there's a law, Factories, Offices and Shops Act, yeah. And that is the law that regulates aspects of some of these things for workers to work under satisfactory, safe, and healthy conditions. Workers have the right to receive equal pay for equal work done, meaning that when a worker works, the worker has to be paid. The worker doesn't only have to be paid, the worker has a right to be paid the same amount of money or similar amount of money with the people who are doing the same job that he's doing, assuming they all were employed the same time and they all do the same kind of work. So all things being equal, two people doing the same thing in the job with the same status on the same grade have to be paid the same thing. Okay, the same basic wages. Okay. Then workers have a right to terminate their own employment at some point when the workplace is not safe, or the workplace is abusive, or the workplace is full of sexual harassment where repeated complaints have not been handled, have not been resolved. Then the worker can themselves terminate their own employment and bring charges against the employer. So the workers have a right, or a worker has a right to terminate their own employment. Workers have a right to form or join trade unions. Workers have a right to form or join trade unions. And any two or more workers can form or join a trade union. But the interesting thing about this right is that it also means the right not to join a trade union. So where workers choose not to join a trade union, they cannot be forced to join a trade union. And they are protected, for example, under, right. So to continue, workers, I've mentioned that workers have a right to form or join a union, and it also means the right not to join or not to form a trade union. Workers have a right to be trained and retrained. It means that where a worker is employed, they have to be trained, not only once, but repeatedly, so that they can upskill and can be more efficient and effective in the execution of their jobs. So workers have a right to be trained and retrained, and it is not a privilege for an organization to train a worker anymore. It is not a favor done an employee to train that employee in the workplace. Workers then also have the right to receive information that is relevant to their work. For every work that the employee does, they have the right to be given information about anything in the workplace that affects the work that they do. So where information is kept from workers for the basic reason I can't tell, it is a breach of the workers' rights, because they have to receive information that often should be relevant to the work that they do. So these are the rights of workers that are outlined in the Labour Act.
Thank you, Senyo. So I'm looking at the right to terminate employment. Is that what makes an employee or a worker decides to resign? And if that's the case, under what circumstances? Should they just get up one day and say, no, I'm terminating the employment and leave? Or there are procedures they need to follow to ensure that they leave?
Of course, there are always procedures they need to follow. In termination of employment, we have voluntary terminations and involuntary terminations. And the right to terminate employment can be both voluntary and involuntary. When it's voluntary, it is called resignation. So all things being equal, an employer cannot prevent an employee from resigning, unless, of course, there are some outstanding issues that requires the worker's attention, which should be finalized before such resignation is accepted. But the more serious one is the involuntary, termination of employment, where the employer makes the workplace unsafe and unconducive for or unhealthy for the employee. And so the employee has the right to stay away from the workplace until that is rectified, or to stay away from the workplace permanently where the whole thing is not rectified. And it will be considered as an unfair termination of employment. Yeah.
Emmanuel is asking,
against the employer. Yeah.
All right, thank you so much. Emmanuel is asking, can the worker sue because he or she is not being trained or retrained? And also, is it compulsory for employers to train their employees?
Yes, it's compulsory for employers to train their employees. An employee can go through the various processes of complaining, and later, if such complaints remain unresolved, can sue. And I don't like using the word suing in industrial relations, but can bring charges against the employer and request that the employer is ordered to train, to comply with the instructions of the labor law under the duties, the rights of the employee, the worker, to train the worker. So the worker can bring complaints against the employee and the employer, and get an order to force the employer to train the worker. Yes, that's possible.
But you explained to us on Instagram that training may not necessarily be the formal, like take you out of the workplace to train you, but it could also be an on the job training. So that could also count for the employer to say that I'm
exactly. Yeah, but you remember I said that you can't just say that on the job training. So, and because the people are working, they are training. No, you need to have structures, you know, that stipulate specific training objectives and training outcomes, and you should be able to prove that people have been trained in the workplace vis-a-vis whether it is on the job training or off the job training or formal training or informal training. You need to be able to prove as an employer that you have trained your workers if you are called upon to do so.
Well, and is it in order to say that such training must be based on the work that the person is doing and should be that which will help the person upskill, like you mentioned earlier?
Exactly.
So you can't just see any training that is not related to your work and then want your employers to send you to that training, and if they don't, and you think that they are not training you. So it's like,
yes, the training has to be relevant to your work.
Thank you so much. Now, let's go to the obligations, because when I shared this flyer, somebody said, and rightly so, that it's a double-edged sword. So it cuts both ways. What are the obligations of the employee or worker as spelled out in the Labour Act?
Yes, anytime I have to share, you know, this part of the Labour Act regarding the duties and obligations of employees or workers, I get excited because workers are the largest culprits when it comes to their obligations at law. So workers have to work, they have a duty to work conscientiously in their lawfully chosen occupation. Insofar as they have chosen to work in that occupation or that job or that role, they are supposed to do it with good conscience. Do it well, basically, is what it means. That you chose to do the job, so you have to do the job well and to apply all your efforts and your talents and your focus and commitment to the job. So workers have the right, the duty to work conscientiously in their lawfully chosen occupation. That's the first obligation. And you ask yourself how many workers really are truly committed to their job other than just doing the job to pay their bills and things like that. Workers, again, have to obey lawful instructions. It's their duty to obey lawful instructions. The only exception is where the instruction is unlawful. But once the instruction is lawful and is related to the job, workers have to do that. And so workers cannot work on their own anyhow they want. They have to work in accordance with instructions. Now, this is the other interesting one. Workers have the duty to report for work regularly and punctually. So they don't only have to report for work every day or every working day that they are required to report for work. They also have to report for work punctually at the time and place that they are required to report for work. So when workers are late, it is not a trivial thing. They are breaching the provisions of the Labour Act. It is not to be taken lightly that a worker is late and so that's it. But it is a very serious aspect of the Labour Act that they are breaching. Workers have to work and have the duty to enhance productivity in the workplace. So how they work and what they contribute to the organization is an obligation on them under the law. So they have to enhance productivity. Then workers have to exercise due care in the execution of assigned work, meaning they cannot work anyhow, and they cannot work in ways that result in cost for the employer. They need to work and make sure that they take due care and do not unnecessarily create, problems for the employer. Workers have the duty to protect the interest of the employer and also other workers. So where workers work anyhow and it is to the detriment of the employee of other workers and also the employer, then they are breaching their obligations under the Labour Act and also under their contracts of employment. So it's very important that some of these things are outlined, under each contract of employment, and workers are made to know about them so that when they breach them, they know that there are consequences, that comes with breaching some of these provisions under the law.
I can say for certain that when it comes to some of the obligations, many employees or workers, they fall foul to them, especially when it comes to working with all their hearts, with their conscience and making sure that they work in the interest of the employer. Sometimes they say that, oh, this is not your father's business, it's not your mother's business. So why are you worrying? Even those who are carefully doing their duties, you find other workers teasing them, like they've taken their work as their own and then as work up and all that. So it means that if you're not doing this, then you are falling foul to the law and the employer can take you on.
Yes.
Wow. But would you advise that these obligations and rights should be made part of the contract letters or employment letters, or that we should refer them to the Labour Act, or if the organization has an employee handbook, we should refer them to the employee handbook, or they should be made part of the contract letter? Which one do you think?
Yeah, I think I already mentioned that. For me, these provisions should be made part of the contract of employment.
Okay.
So that employees know, and we can easily quote some of these things and hold employees accountable to it. So they cannot have an excuse to say that they did not know. And that's why for me, when employers struggle to find things against, underperforming or misconducting employees, I just smile at myself, because there's so much that an employer can refer to under the Labour Act to bring correction to an employee that is not complying with their duties under the contract of employment or under the provisions of the Labour Act.
This then brings me to my next question. Whose duty is it to ensure that employees are made aware of their rights as well as their duties or obligations?
I think that the first one is for the employees themselves. The employees have the duty to know what they are obliged to do, what their obligations are, what their duties are under their contracts of employment and under law, so that when they sign their contracts of employment, they know what is expected of them. Now, if they do not take time to read their contracts and they do not take time to find out what is truly expected of them and what is not acceptable of them, then they become victims of their own ignorance. And you know that ignorance of the law is not an excuse in the execution of law. So that is what I would say. But secondly, if the employees are, members of a union, then the union who takes, dues from the workers has an obligation to train the workers regarding their rights and obligations so that they don't fall foul. And the third, stakeholder is the National Labour Commission, which is normally responsible for resolving disputes. But one of their functions is to anticipate and prevent disputes from happening. And when people know what their obligations and rights are, and it's communicated to them effectively, and they understand their do's and don'ts, then disputes will hardly occur. And even when the disputes occur, it is easy to resolve them because we know black and white what we have to do and what we do not have to do. And so the National Labour Commission is another one. And then generally, I think that the Ministry for Labor and Employment Relations also has a role, in all of the state departments that have to anything to do with labor, including NCCE. They all have the obligations to educate workers on their role. The GTUC, Ghana Trade Union Congress, they all have a role, as stakeholders. And employers themselves, finally, employers themselves have a duty to train and retrain workers. And one of the things that they can train workers on is their obligations under the law and their rights under the law, so that both parties have the same information when they are dealing with each other in the employment relationship and in the workplaces.
Thank you so much, Senyo. I particularly like the point you make, that the duty lies first of all with the employee or the worker himself or herself. What it means is that you need to take steps to ensure that the employment letter you are signing, you do understand the terms that are indicated, because once you sign, it becomes binding on you. So before you sign that letter, you may want to talk to a labor expert, a labor consultant like Senyo, once you can just send your letter to him to read it for you and help you understand what you are signing before you sign. Otherwise, you will find yourself wanting. And if you are an employer or an HR professional, before you issue that letter, sometimes we pick employment letters lying around on the internet and then we issue out without really understanding what we are issuing out. So we should also consult. I mean, we are HR professionals, but people have expertise in other areas like labor contract and all that. So you may want to contact Senyo to ensure that the contract you are sending out there is in order, in line with the labor laws, and that you, the employee or the worker, it's not for nothing that the employer will give you a week or two for you to read the contract before you sign and return it to them. Then it becomes binding on you. So don't just rush into just signing. Just like you need a lawyer, just like you need a doctor, you need some of these people in your life. You also need a labor consultant, so long as you keep on working to cover your back so that you don't find yourself wanting in future. So I recommend that we talk to Senyo. I'm sure Senyo will give his number or social media handles in course of time. Emmanuel says, okay, let me try to read that. Emmanuel says, if an organization seems to be effective and efficient, is it so necessary to still train? Hey, Emmanuel, you're on this training part. Okay, so from what you said earlier, an employee can ask to be trained, but if the firm feels like we are meeting our goal, so don't need these training sessions. So what he's saying is that if the firm is doing well, do they still have to train people?
Well, yes. I mean, for a learning organization, or ideally, organizations are supposed to be learning organizations. Yes. Organizations are supposed to be, innovating as a going concern. They're supposed to be building and strategizing as they go, So for all of the needed, strategies that would take the organization a notch further, as against their competitors, then they need to train employees to be abreast with that. So if we have a new technology, a new way of doing business, instructions that will require, a different kind of knowledge to be able to do the new things that organizations are seeking to do, they need to train their workers. They need to continuously communicate, this knowledge to their workers and find time to train them so that they can be abreast with what the organization needs to do. I mean, if an organization tells me that we are meeting all our goals and so workers don't need training, then that organization is not a learning organization, and that organization does not have a future. Because we don't only train when we are not doing well, but we train when we are doing well so that we can maintain the standards, you know. So that's why we call certain things refresher training, you know. So even when we've trained before, we can retrain to make sure that people truly grasp the concepts and the principles that we are trying to get them to understand, so that they can be more efficient in what they do in the workplace.
Wow. Asantua says, why is it so easy for most organizations to cut training budgets whenever there is a bit of financial crisis or challenge? If training is an obligation, why is it that, you know, they find it so easy to cut a budget for training? Senyo.
Well, the point is that most organizations do not know that most organizations do not know that they are obliged to train workers. Most don't know. That I know for sure. That when we do a survey right now, most organizations don't think that it is law that they should train and retrain workers. That is one. Number two, those that know, okay, have not had to suffer any consequences for not training. Yeah. So there's no motivation to actually comply with the law. So assuming that unions start taking on companies and start paying compensation and start getting orders from courts and the National Labour Commission to train its workers, then that would become an area that employers will know that they don't have to. So now they treat it as a privileged activity, as cost. So if we have money, then we do it. But if we don't have money, we don't do it. So if we have to cut costs, the first thing to do is to go and cut the training budget. Nobody goes for training, you know, and so then we are able to cut costs and manage things. It's just because knowledge is lacking in this area. And until workers start standing up for their rights, just like how workers are now standing up for their rights in terms of termination of employment, which is now making employers quite skeptical in just terminating employment. You know, same may have to happen with training, and then the training budgets will not be cut as the tradition is now, the convention is now. Yes.
So let's stand up to our rights legally, you know, not illegally.
Yeah.
Right. Okay. Boama says, excel and sustain and growth and innovation demand organizations to train and develop employees, magnifying pillars of strategy. I think he's
beautiful.
The point you made about the fact that it's not only when you are not doing well that you train, but you also need to stay ahead of the competition. So you need to train your people. Matilda says, please, what is the difference between locum or part-time work and contract for employment?
Okay. Locum basically is temporary work, and it can be contracted on the basis of on an independent contractor basis or on a temporary basis. So depending on the specific style and the policies of the organization, they can decide to engage locum people on a contract for service or on a contract of service. So that one, they can do a choice. Locum work, basically, for those who don't know, locum work is basically it's like part-time work, but in the health sector, they call it locum. So for pharmacists who do a few hours a day, you know, in a particular pharmacy, will be called locum pharmacists. For doctors who do same, locum doctors, locum nurses, you know, and so on and so forth. So that they can sometimes do as independent contractors in a contract for employment, or they can still do, you know, fixed term employment, or call it temporary contract of employment for the same kind of thing. So it's a choice. They can go either way. Now, part-time employment basically means that the people do less hours than the regular workers. Okay, so regular work is 8 hours a day. So part-time workers do a few hours a day, and the contracts that cover those kinds of work can still be done depending on the individual professions, can still be done either on an independent contractor basis, or they will do it on a temporary basis. So either way it works. But part-time work basically means that people are working lesser hours than others. Yeah.
Thank you so much. As Antoine is asking, is it possible for lawmakers or regulators to ensure this is happening? An example is SNIT will come after organizations when what is due has not been paid.
Well, I think that she means that just as SNIT is a regulator for pensions, and so they are authorized to be able to go after the employer.
Okay.
How can same happen to training? Now, the point is that we have in our law in section 122 labor inspectors. They come from the labor department under the chief labor inspector, who also works under the chief labor officer, right? So the labor department has labor inspectors, and they are supposed to go around institutions to ensure that the provisions such as these in the labor law are being adhered to. Unfortunately, they are not well resourced and they are not many. So at the end of the day, they do not get the ability or the capacity to be able to really enforce this. Now, if we wanted really to enforce our labor laws, then the labor inspectors have enough powers to be able to impress on employers to train their workers. If we really want to do it and we have the commitment and the will, we can do it. And so the labor department will then have to be called upon to make sure that this happens. But currently, when labor inspectors inspect the books of employers and they inspect the workplace, they don't even ask about training and retraining at all. I know I've been involved in a few where organizations have invited me to handle the relationship with labor inspectors who are coming onto their premises, and they don't ask for, you know, whether you train or you retrain your workers and show us proof that you train or you retrain. Nah, we've not gotten there. Not at all. Not at all. Yeah.
We have a long way to go. And that is why we need labor consultants like yourself to help us, you know, stay on the side of law, on the right side of the law. And what am I saying? Will you term self-paced learning and development as infringing on employee rights? I don't know if you understand.
No. Yes, I understand. Self-learning is one of the principles of, you know, career development, where you have to take initiatives to develop yourself and to learn yourself, you know, so that any other additional training and capacity you get from elsewhere becomes an added advantage. That the fact that you are not being trained, then you don't lose out, you know. So yeah, it is not an infringement. It is a personal decision. And so you need to, as a principle of career development, you need to self-develop. And now that people are not being trained and retrained, and that right of the worker is being breached, then you will not suffer adversely, you know. So it is an icing of the cake and an added advantage to self-train, you know, and develop yourself. I don't think that is an infringement on any employee rights per se. Yeah.
Okay. Godwin says, please, how do you treat a female employee who is due for maternity leave, but on a contract that is due in 1 month or 2?
That's beautiful. That's a beautiful question. I've constantly been asked these questions, especially for employers who employ, you know, temporary workers. You know, the fact is that the maternity leave is an entitlement for every worker, every female worker that gets pregnant. But when you get pregnant, the clock of employment, the contractual relationship does not stop. So you get pregnant and you can take your maternity leave, but the clock will continue to tick. When your contract ends, then you are out of the contractual relationship. And so then your contract will end and then you'll be on your own, right? So that is how it works with contract of employment. Because outside of the duration of contract, when the contract expires, the employer does not have that obligation anymore towards you as an employee, because at that point you fall out of the contract of employment. So yes, you'll be on leave, on maternity leave until your contract expires. And when your contract expires, everything comes to zero. Yeah.
Wow. Thank you so much. This has been very, very insightful as well as revealing. I mean, when it comes to the labor law, there's so much more that we can learn. So if you want to learn more, please contact Senyo. Senyo, permit me to give out your number, 0244. Please take note because you need him. You need Senyo, so please take note of the number. And right after here, contact him on any issue regarding workplace or employment law or contract of employment. 0244 79 2728. 0244 79 2728. Again, 0244 79 2728. So send him a message on WhatsApp and he'll respond to you as quick as possible, and then you can start the conversation from there. I also recommend his book to every one of us, whether you are starting your career or you are progressing your career. It's called the Career Toolkit for Successful Job Hunting, but it doesn't only talk about job hunting. It also gives you even what to do with employment letters and all that. So you can contact me if you need copies, or you still contact Senyo. So how much is a copy of the book? If you can,
it's 50 cedis.
Okay. And it's worth it. I tell you, I have personally taken time to go through the book, to read it, and it has become my guide. So please, you need a copy. If an HR professional, you are a worker, you need a copy, or even if you're an employer, you need a copy. So you can contact Senyo once again on 0244 792728. 0244 792728. Thank you so much, Senyo, for your time. And remember that career coaching and mentoring class is brought to you by Standard Consult with support from Logo Brand. Please contact Logo Brand on 020 395 4216, 020 395 4216 for all your branding and graphic designing needs. Yes, so Senyo has written his number down, so please pick it up and contact him. You would never regret it. Thank you so much for joining. I think Asanto also has, Senyo, maybe the last question before we go. Asanto says, how do you treat a female employee who joins an organization pregnant but doesn't disclose? This one, you have to pay Senyo for consultancy. So disclose when she has joined. Will her probation of 6 months be on hold if she has to go on maternity leave?
It depends on the policies of the organization. Now, for some organizations, when you don't disclose and you join, they see it as dishonest. So they end up using that against you in the probationary period, and they do not confirm your employment. Now, so they treat it as such. So they will not confirm your contract of employment at the end of the probation, or they may even use other grounds to just end the employment contract. So it's always good to disclose. There are some organizations, however, which policy require that when you come in and they find that you are pregnant and you have to go on maternity leave, They can freeze your employment and you go on maternity leave, for which they do not pay you at all. Or depending on the policy, they may pay you only your basic wage until maternity leave is over, and then you return to work to continue from where you left off. So they'll freeze your employment and the clock will be frozen because you are still in training, you are still on trial, you are not a full employee yet, you are not a confirmed employee. They will freeze the employment and then have you go and take care of everything. Sometimes they'll pay you a little allowance, sometimes they'll pay you your basic wage without the allowances, and then they wait for you after 12 weeks. When you return, you come and continue, finish your probation, and then they confirm your employment and you continue. So depending on the organization you are working with, sometimes you get to continue working after your maternity leave. But for most organizations, I know that they would then terminate the employment on the basis of probationary termination, and they don't need to give notice or anything during probationary termination. And so they end up, ending the employment contract on the basis that you've not been honest to them.
Thank you, Senyo. I know that we have a lot more questions, but there's a product, Senyo, that you have. I don't know if you want to introduce that and then add your final words so that when it comes to labor law, where they can sign on to it and then enjoy the services. If you can share that with us and then also give us.
We have a product, labor law clinic, which is a monthly subscription for any advisory services that a person needs on the labor law and its application. It is 99 cedis for the month. And so a subscription for the month, so 99 cedis for the month. And during this period, a person has all access to all and every advisory services they will need regarding anything regarding in labor. And it is 24/7. They just need to use all of our social media handles to post their questions. So they can do it by email or any other way, or by phone call. It is 24/7 service, and we'll give them the necessary response to their questions. It's 99 cedis. So what I want to say is that let us be careful as employers how we craft our contracts of employment and what we put into those contracts of employment, and always run it by templates, by experts, to be able to be sure that all the provisions are compliant with the law and it's applicable to the right types of contract, the right types of jobs, right? And for all employees, we say that they always need to know what they are signing. They need to know what their duties, obligations are, and their rights are under the contracts of employment and also employment law, so that they do not breach employment contracts and then get into trouble thereafter. So I want to thank everybody for the opportunity opportunity given me to share these ideas with them on this aspect of the labor law. Thank you very much, Patricia, and also Sedat Consult for the opportunity.
Thank you so much. Edna is clapping, but let me find out the 99 Ghana cedis per month. Is it that when you pay, you enjoy for a month, or how should I say it? Okay, like if I pay right now, will the contract end at the end of October, or it will end? Today is 11. It will end on the 10th of October.
It will end on the 10th of October. So it's 1 month exactly.
One month exactly. I will encourage all of us to sign on. It's really helping a lot of people and helping organizations to, avoid the labor commission wahala and all that. Thank you so much, Senyo. We are very grateful. Thank you, everyone. Thank you, everyone. As Atwa says, thank immensely. Really appreciate this session. Is there a discount for 1 full year, Senyo? If the person wants
there's
for 1 full year.
Yes, there's a discount for a year, yes.
Yeah, so as Antoine, please pick Senyo's number and contact him. I'm sure that you will have a nice conversation with him. Thank you, everyone. Gordon will meet again next week on career coaching and mentoring class. Thank you, Senyo. We can't thank you enough. We are very grateful for the time and the expertise and the insight that you shared with us. God bless you more and more. Thank you, everyone. See you again next week. Bye-bye.
Bye.
Bye, everyone.